All right, good morning, everybody. Welcome to another Power 30. We are so happy to have you on the call. And we are really excited to have with us today somebody that I have known for a very long time, a friend of mine, Mr. Corey Schmutz. And Corey is going to do an intro for himself, but he lives and breathes in the world of estate planning and probate. Before we dive into the good content of it, I'll just remind everybody that unless you're going to pipe in and say something, or if when we get to the questions portion of the call, please keep yourself muted so that we don't pick up your background noise. By this point, everybody's an expert on Zoom, so this should be no problem. All right, so welcome, Corey, and thank you so much for being willing to be our Power 30 guest this morning. Glad you could be on the call. Why don't we start by having you just tell us a little bit about yourself?
Perfect. Sounds great. Thanks for having me. So Corey Schmutz, and I work at the Jeffrey Burr Law Firm. Been an attorney there just over 10 years, and kind of all we do is estate planning and probate. A little bit about me. I was born and raised here in Las Vegas. In fact, grew up pretty close to Cody, and I've known him for years and years. And went to UNLV for my undergraduates in finance and my law degree also from UNLV, and then have a master's in tax law at the University of San Diego. So I'm kind of a tax nerd. We deal with a lot of taxes when it comes to estate planning and probate, just by the nature of it. So that's a little bit about me.
Yeah, so to most people, that would sound like some pretty boring stuff, but to numbers guys like me, I like that. I don't know about tax. I don't know if I would like it or not, but yeah. So normally we have Joe do these interviews, but I asked him if I could take this one because I know you, and as I was preparing for this, I actually couldn't remember exactly when we met. I mean, it was like we were both going to the same school and stuff, and so it must have just been through our normal course of being in that school, but I don't really remember exactly when that was. Do you remember?
No, it's been a long time. I'm guessing when we were 10 or 12 years old, probably, maybe younger.
Yeah, that's what I would guess too. Okay, cool. So let's jump in. What I'd like to do to start with is, I hear a lot of people on the street, including realtors or amongst clients, who think they know what estate planning is, but really I can tell from the conversation that they're sort of way off. So let's have you give us, what are the basics of proper estate planning, why it's important, how much it costs to do some of these things, just generally speaking. And then from there we'll understand. I think it'll be a good background for going into the probate subject.
Perfect. Well, let me kind of start with what estate planning is. And really it's just getting a plan. And when I say a plan, usually it's a set of legal documents to do a couple things. First, we want to make sure we have a plan in case someone passes away. So when we talk to estate planning, we're usually dealing with, death and incapacity. Those are real fun things to talk about. So we want to make sure all the assets that you've worked hard and accumulated during your lifetime, that there's a plan in place where if something happened to you, those assets will be distributed to your beneficiaries, whoever those could be. And, in Nevada, you can name whoever you want, even your pets if you'd like to. And so make sure that when you pass, everything is real smooth. So we do a couple of things. We typically want to avoid any court process, and that's what probate is. Probate's just a court process, so that when you pass away, you pick somebody to be in charge and they can distribute out your assets without having to get court involvement, pay a whole bunch of money and attorney fees to go through the probate mess that we'll kind of talk about a little bit later. And those documents typically consist of, if you own any real property at all, or if you have, children, you want to make it easy for them, you typically want to put together some kind of revocable trust. Could be an irrevocable trust too, if you have a lot of assets or need some asset protection. But a trust is kind of the key part in doing that. Everybody with a trust is also going to have a will. So you have a trust, you have a will that goes with it. And then another thing that's really important when we talk about estate planning is planning for your incapacity. So if you ever, end up with Alzheimer's or you get in an accident or something, we need some documents to make sure that someone can manage your assets during your incapacity, to make sure everything's taken care of, that your bills can be paid, that your healthcare decisions can be made. So those kind of consist of a bunch of documents. We have the trust as kind of the main piece on that. And then also you're going to have power of attorney documents for healthcare and finances so that somebody can manage your healthcare decisions for you. You put directions in there, whether you want the plug pulled in certain circumstances, if you're in a coma or things like that. And it's kind of funny that you mentioned that some people think they know what estate planning is, and then you talk to them and you realize they really don't know. We see a lot of real bad estate planning in the office. And I run the probate department, and a lot of times bad estate planning equals probate. So I end up trying to fix it on the back end. Sometimes we can fix these problems and sometimes we can't. Probably one of the worst things you can do is go online and get a form and try and do your own estate planning. A lot of times you'd be better off having done nothing at all. We see a lot of problems there. And so that's kind of it. It's really just estate planning, setting some legal documents up to make sure we take care of death and incapacity, that everything's smooth. Right now, I'm telling people that come in to do a probate, our court's way behind because of the COVID mess. And so we're typically telling people, well, from start to finish, you're about 12 months in a best case scenario.
Wow.
So that's really, really nasty right now.
Wow. Okay, so let's unpack a little bit of that, just a little more on some of the stuff you mentioned, because years ago I set up a trust, and I believe it has a will associated with it. But honestly, I can't really figure out why there's the need for the will, because it looks like the trust documents say this is what happens to all the assets. And, like, I know that my love is really important, but from a estate planning perspective, it's only the assets that we care about here. So
Right.
Doesn't the trust, why is there those two that interact there together?
Yeah, great question, especially important now. The trust really does all the heavy lifting, right? So when you do your trust, you're going to say, okay, my son Johnny's going to get a third, my son, Timmy's going to get a third, and whoever else is going to get a third. So all that happens in the trust document itself. It says who's getting what. The will is really just there as a safety net. So the will is very interesting. It says, okay, whatever assets I forgot to put in my trust, because when we create a trust, we also have to retitle assets into the trust. So the will becomes this safety net. If you forgot to put anything in the trust, retitle it in the trust. The will says everything else that would ordinarily be subject to probate just dumps over into the trust. So we call that a pour over will, just like it sounds, it pours over into your trust. And the nice thing about it, so let's say I bought a house and forgot to put it in my trust, that pour over will catch it and dump it in there after my passing. But the nice thing about it, we just fixed our statute to allow this, and in October it became effective. If you have one of those pour over wills and you miss something, you don't have to go through probate anymore. You just go in front of the judge one time and say, dear judge, oops, we missed this property, and the judge will dump it in there without having to do a probate.
That's good. Yeah. Okay, great. And I'll tell you that happens. You kind of, as in your world, you deal with it every day as, like, the person on the street. I got that thing all set up. I had my whole future figured out, and then the future comes and it doesn't quite go the way you thought, and assets go in and out and you forget. So thank you for explaining that on the will. Okay, yeah, so let's do then go into the probate process now. My understanding is that, as you mentioned, the trust kind of is the official owner of the asset, so it doesn't have to require a probate court to say what happens to the asset. But in some cases there might be, and in fact, I've seen in my career as a realtor, I've seen a lot of probate transactions occur. So why does the probate have to happen, and what does it look like generally from a court's perspective?
Great question. And probate's kind of a long, complex thing, so I'll try and keep this as concise as I can. So probate is what happens if two things occur. One, if you don't have a trust, you'll end up in probate. If there's also no beneficiaries designated on things. So I could have $1 million account at, TD Ameritrade or somewhere. If I name beneficiaries on that account, it won't have to go through probate. That automatically will go to those beneficiaries. Becomes real difficult with real property because we can't really name beneficiaries efficiently. So if I've got a house, I don't have beneficiaries listed on it, obviously. And if I don't have a trust and a pour over will, that title to the property gets stuck in my name when I pass away. So like if you go look at the assessor's office where the title records are, typically when you own property, unless you have a trust or an LLC or something, you own it in your individual name. When you pass away, your kids can't just run down to the recorder's office and go sign that title back over to the beneficiaries. That has to go through probate, and the judge will issue an order to assign the title over. So that's really all probate is. It's just that court process of getting title transferred from a deceased person's name to whoever the beneficiaries are.
Okay. So let's go from a seller's perspective first, and then we'll come back around and just fill in any gaps that we need to talk about from a buyer's perspective. My understanding, and you tell me where I have this right and wrong. My understanding is that when a seller lists the property, the seller is basically going to the market and saying, I want to sell this property, but it's going to be subject to the probate process. And the buyer needs to be aware that they're not just going to close on that through a normal escrow process with normal escrow timing. Instead, there's going to be a process that has to go through the courts. And then the parties are essentially going together to the court to ask the court to bless that transaction. And if the court ultimately does that, then the sale can happen, escrow can close, and the buyer can own the property. Is that generally the process?
Yeah, that's kind of it. And let me just unpack that a little bit. So I'll kind of start at the beginning. So let's say a client comes into my office and says, hey, mom passed away, title is stuck in her name, we need to do a probate. So the first thing we do is we go into the court and we file what's called a petition that says, dear judge, someone's passed away, we need to open probate. So we file those documents, that petition, and the court's going to set us a hearing date to appoint either an executor or administrator, depending on whether there's a will or not. So the downside to this is it takes us 3 months to get a hearing date right now with the backup of the court.
Wow.
So we go into court 3 months later, we get an executor appointed, and the executor, we know they're appointed because there's actually a court order saying you are now hereby appointed as the executor. So when you're selling property, you really can't do anything until you have that first court hearing and the executor administrator is appointed, because otherwise you have nobody legally authorized to sign the purchase agreement or the listing agreement. So that's kind of step one, is we have to get that executor or administrator appointed. Once they're appointed, if you represent the estate or the administrator, you get that court order, your client gives you the green light that says, yeah, go sell my property. You're going to list it just like you normally would do. Put it on MLS, make sure you get a good price for it. Just like you normally do, you'll enter into a purchase agreement. The only difference is the purchase agreement has to have some language that says this sale is subject to probate court approval. So that's the only difference that's required by the court there. So then we have to take that contract, and now we have to go back into court, and the court has to approve the contract. So that's what Cody's talking about here. Now we got to go back to court and get the court approval. So really what the court's doing is they're just confirming that sale of that contract that you've entered into. So we go back into the judge again. Now we got to wait another 3 months to get a court hearing date. And then we have that hearing. And at the hearing, again, we're just confirming the contract, but it turns into a live auction at the courthouse. Right now, some of these, most of these hearings are done online. So we kind of do like a Zoom call like this, where if anyone wants to bid on the properties, they can bid at the hearing. and they're just bidding. So if the contract's 300,000, the judge will usually start at 5,000 over contract price, and it could turn into a bidding war. The original buyer can still bid on that property, but the court's just making sure we get the most value we can for the property. If you show up at the hearing and nobody bids on it, then it just closes for that contract price at 300,000. So that's kind of how the hearing works. And it really creates a problem because it takes us 3 months to get in front of the judge. There's also something you guys need to be aware of. It's called the Independent Administration of Estates Act. You don't need to remember that name, but it's another way to do probate, where if the attorney right at the beginning opens the estate and appoints the executor under that Independent Administration of Estates Act, it allows the executor to sell the property without that second court approval. So what you do in that case, and the attorney will kind of guide you as to whether they're using it or not. We probably use this thing 80% of the time at this point, sometimes 90. And your executor can sell your executor will tell you to sell the property, you get a buyer, and then we just send out consents to all the beneficiaries as long as they sign off on it. And the sell price can't be less than 90% of the appraisal price. We could skip that whole hearing, and so we don't have to wait 3 months for approval. So that's really important to know. You'll see more and more firms using that than used to, just because of the big delays that we run into.
Yeah,
I
that's
know that was a lot.
Yeah, I didn't know that. 3 months just to get on with the court. For a minute there, I found myself thinking we needed more lawyers and judges, but then I came to my senses and realized that's the last thing we want. So,
I did.
no, so in all seriousness, though, how long has that more expedited process been around?
It's been around since 2011. So when it first showed up, we didn't see people use it very often. Our office was one of the first that started using it, and there was a few other ones. Now that the hearing dates are so far back, you're seeing a lot more people switch over to it, but it's still probably 50-50.
And why would that not have been adopted really quickly? It seems like it's an easier process.
That's a real good question. We think it's just because it was new and people didn't know what to do with it and how to use it. We found it to be really helpful. Some attorneys worry that if you don't have the court approval, there might be some liability for the executor. But my response is, well, if all the beneficiaries are signing off on the sales price, then you don't have too much to worry about.
Yeah. Okay, so let's back up then to where it does go through the probate and it is in front of the judge. So I've seen this before. I've actually attended a couple of these hearings because I just wanted, when I was new and learning, I wanted to see how it worked. And it was just like you mentioned, where the judge opened it and set the next highest, starting bid or whatever be 5,000 higher than the purchase price in the contract. And in the two that I attended, and in all the other ones I've ever done, that's just been approved. Nobody was there to bid. But in this kind of a market where it's really hard to find houses, if I was representing a buyer, I'd be certainly a little bit more concerned about that. So let's take it for a second from the buyer's perspective. Let's say that it's a $300,000 purchase price, like you mentioned. The judge opens it at 305, and the second buyer says, I'll buy it at 305. How does that happen? Is the buyer there physically? Is there a lawyer for the buyer? Do they just raise their hand? Is there a little auction paddle? I mean, what does that actually look like?
Great question. A few things we need to know. So one, the COVID procedures are a whole lot different than it used to be, right? So the way it works now is we set these things for hearing, and if anybody wants to bid on the property, they actually have to file a notice of intent to bid. So if you're the original buyer in the contract, obviously you don't need to do that because you're already on contract. But the overbidders, they will file. And right now, like you said, we've got a tight market. There's a bunch of hedge funds that are kind of involved now, and they will file one of these notice of intent to bid on pretty much anything that we set in front of the court. So you're probably going to have somebody there to bid on it. So if you represent the buyer, this is very important. You need to make sure your buyer is aware that this can happen, because you don't want your buyer to lose the property and say, hey, wait a minute, why didn't you tell me about this?
Right.
So that's super important. I've seen that happen a number of times too. So make sure your buyer knows about this process. And there's always kind of a Zoom call. They're always Friday mornings at 9:30. So make sure the buyer's agent has been in touch with the attorney for the estate, and make sure they get that Zoom link. The thing that's a little tricky is they send the Zoom link out like Thursday afternoon and the hearing's Friday morning. I've had some buyers show up at the courthouse and try and like protect their bid, and nobody will let them in. The court's not there. They're
Right.
doing this from in chambers. So
Right.
you have to make sure that your buyer, if you represent the buyer, that they know what the process is, that you get the Zoom links, because the buyer can show up and protect their bid. If somebody bids 305, the buyer can jump right back in at 306 or whatever. But there are a lot of hedge funds and things going on where they're bidding on these properties. So pretty likely you're probably going to get some bidding action on it. Although I've had a few times where they file these notice of intents to bid and I show up at the hearing and then they just say, okay, we're not going to bid on it. So
Yeah, they were just keeping their place in line. So
exactly. Yeah, exactly.
So let's say then that, so two questions on that. The first question is, do they have to be a cash buyer in order to bid at the probate sale? And the second question is, we now have a purchase contract with buyer one, and buyer two ends up winning the bid at the court. So then what if, like, are the terms already determined? What if the buyer and the seller can't really agree on all the other terms besides just price?
Yeah, and this is important too. And I've had buyers get into this trouble before. So when you go into bid at the court, you're bidding on the contract. So the contract has already been created and the contract's been filed with the court. So you can actually review that contract as public records. So when the overbidder, we'll call it, buyer two, the overbidder, when they come in to bid on it, they're actually bidding on that same contract that's been filed with the court. The only thing that changes is the sales price and the name of the buyer.
Oh,
So
okay.
if you go in to bid on this thing, you have to know what you're bidding on. You're bidding on that contract. So if it says it's a cash deal, you can't come in and try and change the terms of it. Now, if it's a loan deal and you want to pay cash, nobody's going to care, right? Because they just want to get paid. But yeah, you can't change the terms. In fact, I had a hearing one time and somebody overbid on it, and I got a call Monday morning saying, hey, yeah, we won the bid on the property. We want to change the terms because in the contract, the seller was paying all, or the buyer was paying all the closing costs, and that's not what we want. And I just laughed. I'm like, well, you bid on the contract, you're stuck with it. You can't change it now. So that's important to know. If you represent the buyer too, they need to be aware if they're bidding on it, they're stuck with that contract.
Okay, that's cool. I did not. Maybe I knew that at one point, but I had forgotten that I knew that.
Yeah.
I did. Okay. So, but if it is a cash, or sorry, if it is a finance deal, and that person wants to come, the overbidder wants to come in with financing, since that's in the contract, they technically could do that as long as the terms that are negotiated there are what they do.
Yeah, so you have to look at the contract and make sure, because sometimes there'll be conventional loans, sometimes there'll be VA loans. So you just need to make sure what you want to do on the financing is the same thing in the contract.
Okay. We have a couple questions in the chat here. Katie was asking, how would we, I think meaning like a buyer or a buyer's agent, see the contract in advance?
There's a couple ways you can get it through the courthouse, although, I don't know how tricky it is to go down to the courthouse right now. You could also call the attorney's office for the estate, and they should be able to send you a contract, or the seller's agent would probably be willing to send you the contract.
Okay. And then do the buyers have to prove in advance that they have the ability to perform on the contract?
That's a great question too, and it's interesting, but they don't. So you get these overbidders in there, and they don't have to show any proof of funds or anything like that. Now there is some teeth in the statute that says if they overbid on the property and they don't complete it, they're liable to the estate for any damages that they cause. So we can go after them if they back out of the deal without some term in the contract allowing them to do that.
But that would usually entail some kind of like another court process. And
right.
My experience is that the heirs just want the money. They don't want more court. So
yeah, you're right. So if the overbidder backs out, sometimes it's difficult to, go after them. Although we've done it before, but it's unusual.
Yeah. So I really wasn't planning on this, and we only have a couple minutes longer, so we probably can't really go into depth on this, but I'm wondering if this actually might be a strategy for a buyer's agent who's having a hard time finding the right property to just kind of be watching for this and maybe represent that buyer in an overbid situation. Do you see much of that?
Yeah, we see a lot of overbids on these properties, so it could end up being a good deal. Like I say, it's gotten a little tricky because there's a few hedge fund bidders in there, and they just come in and kind of wipe everybody out. So that's been the case over the last year or so.
Yeah.
They got unlimited supply of money.
Yeah. If the first buyer, so if the overbidder comes in and bids the 5,000 over, and then the first buyer bids higher and gets the property, so they end up with it. And then for some reason that deal falls apart, because we sometimes see escrows fall apart. What happens then? Does the overbidder get a shot, or does it go all the way back to the beginning and they have to put it back on the market and get a new buyer and start it
Yeah,
over again?
that's the mess. They don't have to put it back on the market, but you have to start over on the court process, which is a nightmare.
Yeah.
And that's why you see us using that Independent Administration of Estates Act, just because it's so much, with the 3-month hearing date. Although I will note that the court is trying to work on a process for these cells to get it on what we call an order shortening time, meaning hopefully we don't have to wait the whole 3 months.
Yeah.
This is kind of new as of 3 or 4 days ago. In fact, I had a call with the law clerk up there last week, and we got one that we need to get heard a little faster. And he's like, well, we're working on it, but we don't have any answers yet. So we might get a little bit of an expedited process for these for these cells. We just don't know what it is yet.
Yeah. Well, Corey, we're out of time. I mentioned to you that these things go really quick, and I hope everybody else has found it to be as content filled as I have found it to be. The purpose of Power 30 is we get on, we talk about a lot of really good stuff quickly, and we get on to our day. And we know you're busy also. So what we'll do is we have a communication thread through WhatsApp to all of our realtors. We will put your contact info out there so that everybody has it. And if they have client needs or future questions or whatever, then they can reach out to you that way.
Perfect.
Really, really appreciate you being on. And at some point, I'm going to be contacting you to talk you into teaching a CE class with me, which will be similar to this, but a little bit more detailed.
Yeah, that sounds good. In fact, we've done quite a few CE classes for real estate agents, so be happy to do that.
All right, cool. Very good. Well, thanks again, and have a great day. And maybe we'll loop back around here in some months and fill in some of the gaps that we weren't able to cover today.
Sounds good. Thanks for having me. Appreciate it.
All right, take care, Corey.
All right,
Appreciate
take
it.
care.
Thanks.